That's it?
Yeah, you gotta wait.
Okay.
Oh, wait. Take this.
All right, got it. Hey, Holly? Alan has got Michelle's name on it.
Oh, I'm using her computer.
Jimmy, did you want Gary on today or not?
He's with you there?
No, he's not. He's at the Woodlands office. So
Okay.
it's up to you.
I think he should.
All right, let me call him real quick. Call Gary Jewell. Yeah, I asked Jimmy if he wants you on. He said yes. So we're all on, just waiting. Dan Laney's on. Abby hasn't joined yet, but other than that, the local council's on. Alan's on. I'm on. So Jimmy wants you. Okay, bye. Hey, Alan, you need to put your thing on mute. Put it on mute, please.
Leave me alone. It's the fear that I'm going to screw something up that makes me less likely to just Catherine, you're on.
I think I'm on.
And we can hear you guys talking.
Mute again.
Good morning.
Hi.
All right, we're getting ready to start the hearing. So I'm going to ask everybody to start their video. And those attorneys who are, if you're not going to be arguing, you can remain muted. Who's going to argue today? Could I ask that?
I will be arguing for Merrill Lynch.
Jimmy Fall for the plaintiffs. And Mr. Christian may argue some.
All right. All right. I think I am hearing some reverb from our YouTube. All right, well, I'm going to turn my mute off. Judge Goger's going to be joining us shortly. And does anybody have any questions before we begin? We've gotten everybody's. Yeah. I'm going to mute myself and we'll start shortly.
Thank you.
Good morning.
Good morning.
We're all here, I take it, huh? Are we ready to begin? Yeah?
Plaintiff's ready.
Defense as well.
All right, well, let's begin.
I'll go ahead and start, Your Honor.
Fine.
Abby Rudson from O'Melveny and Myers for defendant Merrill Lynch. Nice to see you. We're here today on Merrill Lynch's petition for attorney's fees. The court has already held that under OCGA 91168, Merrill Lynch is entitled to its reasonable fees and expenses in defending the Utah plaintiff's claims after its good faith settlement offers expired. During that, what amounted to more than 3 years of litigation thereafter, Merrill Lynch paid attorney's fees of approximately $1.3 million. And we are asking for the Utah plaintiffs to pay their pro rata share of that, which is about 13% or $172,000. We think both figures are reasonable for the amount of litigation. In those more than 3 years, the defendants, Merrill Lynch, had to file or brief 4 separate motions to dismiss, all of them directed at the claims of the Utah plaintiffs. We had to brief a motion for reconsideration of your dismissal of the claims of the Utah plaintiffs. The Utah plaintiffs then appealed, so we had to brief their appeal and present argument to the appellate panel on that appeal. And of course, we had to respond to discovery. The Utah plaintiffs issued 4 sets of document requests alongside the other plaintiffs, of course, and Merrill Lynch produced thousands of documents in response. All told, the work required about 1,450 hours from attorneys and professional staff at my firm, and 2,300 hours of attorneys and professional staff at our co-counsel in Georgia, Rogers and Hardin. Merrill Lynch shared Rogers and Hardin with the other 3 defendants, so it was responsible only for 1/4 of its fees, which is 581 hours. And if you add that to the O'Melveny hours, it's more than 2,000 hours for the 3+ years of litigation, and it calculates out to $648 per hour, which is a reasonable rate for experienced, knowledgeable, efficient lawyering. All of these figures can be calculated from the detailed billing records that we provided to the court and the plaintiffs in January. Those records lay out for every specific timekeeper the time entry of what the task was done and how long was spent on it on that day. The plaintiffs have had these time entries for over 2 months now and haven't pointed to any entry that's unreasonable, that was done by the wrong level of timekeeper, nothing like that. There are 2 ways in which Merrill Lynch's evidence of its fees differs from the typical fee application, and therefore the cases addressing fee applications. But neither of those means that Merrill Lynch hasn't proven that its fees are reasonable. First, only 5 of the 39 plaintiffs, the Utah plaintiffs were only 5 of the 39 plaintiffs that sued Merrill Lynch. And the work done was generally for either defense of the case as a whole, such as responding to discovery requests issued by all plaintiffs, or for briefing the issues specific to the non-Georgia plaintiffs, where the Utah plaintiffs were 5 of the 28 non-Georgia plaintiffs. There is no way to separate out work done for the Utah plaintiffs versus work done for other plaintiffs, particularly the other non-Georgia plaintiffs. So a pro rata allocation is reasonable. Now, we could make a case that the Utah plaintiffs should have to pay 100% of the fees for work that we did for their claims, whether or not other plaintiffs were around. The work is the same. The responding to the discovery request is the same, whether it's the Utah plaintiffs or the plaintiffs group as a whole propounding it. The briefing on the non-Georgia plaintiffs motion, for example, is the same, whether everyone's from Utah or other states. And that we would have had to do it anyway approach was actually sanctioned by the 11th Circuit as the correct approach in EarthCam Inc. versus Ox Blue Corporation, 658 Federal Appendix 526. There, the court held that the defendants were entitled to their fees under Section 68 for the state law claims that had been brought against them, but not the federal claims. The 11th Circuit affirmed an award of the defendant's attorney's fees with just a modest deduction for the time spent on tasks that on their face related exclusively to the federal claims, the claims that they were not entitled to their fees on. The court wrote, "It is impossible to reconstruct the time allocated to each different claim in a case like this, where federal and state claims arising from the same essential operative facts substantially overlap, and where the litigation activity benefits advocacy on both sets of claims. In the court's practice and judicial experience in cases like these, the better approach is to evaluate what legal services and expenses would have been incurred if the plaintiff had not asserted its federal claims and relied only on its state law causes of action." The same is true here, Your Honor. The claims of the Utah plaintiffs completely overlapped with the claims of the other plaintiffs, and there's no way to separate out when we're drafting a motion to dismiss the claims of all the plaintiffs, whether it's for the Utah plaintiffs or for other plaintiffs. And so, according to the 11th Circuit, the better approach would be that Merrill Lynch would get all of its fees on those tasks. And that, of course, is the vast, vast majority of Merrill Lynch's fees. But we're not asking for that. We're just asking for their pro rata share. There's no fancy statistical analysis, as the plaintiffs seem to imply. It's just a straight percentage of their pro rata share based on their representation in the plaintiff group as a whole. It can't be, as the plaintiffs seem to suggest, that we should be at the opposite end of the spectrum and get nothing because we can't prove that a task was dedicated exclusively to the Utah plaintiffs. Rule 68 is about encouraging settlement. It's about encouraging people to make good faith settlement offers and parties to accept them. That's what happened here. We made a good faith settlement offer. Therefore, under the statute, Merrill Lynch shall be awarded its reasonable attorney's fees and expenses. And in a multi-party case like this, it's reasonable to do an allocation. Now, it is true that there might be a task here or there that doesn't relate to the Utah plaintiffs at all. As I mentioned, the plaintiffs had our billing records for months, and their response does not point to any particular task. They do say, however, incorrectly, that there was some motion to dismiss the claims of the Georgia plaintiffs alone that they weren't part of. In fact, they say it multiple times in their brief, and I'll quote just one place. They say, absolutely none of the time, with none, their emphasis, absolutely none of the time expended by Merrill Lynch in drafting motions and briefs and arguing motions to dismiss claims by Georgia plaintiffs involved the Utah plaintiffs in any way. That statement is simply false, Your Honor. There was no motion to dismiss claims by Georgia plaintiffs, and there weren't motions to dismiss to which the Utah plaintiffs had no relation. Recall that what happened here is that the defendants moved to dismiss the claims of the non-Georgia plaintiffs on the grounds that under Lex Loci, they couldn't get the benefit of Georgia statute at all. That was a motion to dismiss the Georgia statutory claims they brought, saying they couldn't get out of the gate. There was a second motion to dismiss filed on behalf of the defendants that sought to dismiss the entire case, all the claims asserted by every plaintiff, on the ground that the plaintiffs had not pleaded the elements of their claims. So for purposes of the Utah plaintiffs and the other non-Georgia plaintiffs, it was effectively an alternative argument. The first argument was they can't avail themselves of the statutes at all. And then even if they can, Your Honor, they haven't pleaded what they need to plead for those statutory claims. Oh, and they can't state their common law claims either. So the second motion concerned their claims just as much as the first. And in fact, the court granted our motion to dismiss on some of the statutory claims, saying that none of the plaintiffs had pleaded claims under those statutes, and dismissed the Utah plaintiffs' common law claims. That's the reason the Utah plaintiffs' common law claims were dismissed. They weren't addressed in the Lex Loci motion. So we're not saying that there isn't the odd task that was done for someone that wasn't one of the Utah plaintiffs, but that is far outweighed by the tasks that were done either exclusively for the Utah plaintiffs or for the non-Georgia plaintiffs as a group, for which the Utah plaintiffs should bear a higher percentage of responsibility. I'll give you a concrete example. When the court granted our motion to dismiss, the non-Georgia plaintiffs did two things. First, they moved for reconsideration and filed an amended complaint, which required more briefing and argument. And then when they lost that, they sought and obtained an interlocutory appeal, which required another brief in response to their appeal and argument to the appellate court. So I took a look through O'Melveny's time records and searched them for the words reconsideration or appeal. It's obviously very rough, but it's a way to isolate the time spent on those tasks which were exclusive to the non-Georgia plaintiffs. And it totals to more than 200 hours. Now, the plaintiffs point out that after they appealed, the defendants cross-appealed. And so there was a brief put in by the defendants to the Court of Appeals asking the court to reverse your refusal to dismiss some of the claims. But again, the plaintiffs have it wrong. They say in their opposition that Merrill Lynch counsel argued to the Georgia Court of Appeals the Merrill Lynch appeal of this court's denial of the Merrill Lynch motion to dismiss claims by Georgia plaintiffs. Again, no motion to dismiss claims by Georgia plaintiffs, no specific Merrill Lynch motion to dismiss or appeal at all. And most importantly, it's just false. I did that argument, Your Honor, and I argued only in opposition to the non-Georgia plaintiffs' appeal. The briefing and argument on the cross appeal, the other half of the appeal, was handled by Sullivan and Cromwell. The argument was done by Richard Pepperman of the Sullivan and Cromwell firm. But in any event, whether it's 150 hours or 200 hours, the point is the same. We are asking for the same 12, 13% of those fees as we are for the case as a whole, even though for those tasks, their pro rata share is more than 17%, because those tasks were exclusive to the smaller non-Georgia plaintiff group. I'll give you another more obvious example. Toward the end of the case, the Utah plaintiffs filed a voluntary dismissal without prejudice, which caused the defendants to file a motion for final judgment on their claims. They opposed that motion. We had to do a reply. Your Honor actually issued a written decision on it. All of that was pretty much exclusively for them. So we should be entitled to 100% of those fees. But again, we're only seeking their pro rata share based on the case as a whole. It is reasonable to ask the Utah plaintiffs, who were part of the case, they were part of all the motions to dismiss, they were part of all the discovery. All we're asking is that they pay their 12 or 13% pro rata share of litigating the case as a whole. It's perfectly reasonable. The second way in which Merrill Lynch's evidence differs from the typical case, again, doesn't suggest that Merrill Lynch hasn't shown its fees are reasonable. It's that O'Melveny did not bill Merrill Lynch by the hour. You might have read, there's been a lot written in the legal press about the death of the billable hour. Sophisticated repeat litigation clients like Merrill Lynch and Bank of America, its parent company, don't want to pay their attorneys by the hour. They want to pay for the value of the work. They negotiate for fee arrangements in which they get discounts, in which they can have more regular billing, and in which they require the firm to be as efficient as possible because the firm has skin in the game. That's what Merrill Lynch did here. Of course, it doesn't deprive Merrill Lynch of the benefit of the statute. Merrill Lynch's fees, they paid about $1 million to O'Melveny for these 3.5 years of litigation. Those fees are reasonable. What's the best evidence of reasonableness? It's the fact that Merrill Lynch paid them. Merrill Lynch negotiated the fees, insisted on discounts, and it still paid the fee. Merrill Lynch took many other steps to try to limit what it paid for its fees, as mentioned in my affidavit. They agreed to share Rogers and Hardin with their competitors to reduce the cost of Georgia counsel. They used a third-party discovery vendor to collect, search, review, and produce their documents, rather than paying attorneys at my firm to do it. They do not pay or overpay for legal services, and yet they paid $1.3 million for this period of litigation because that is the reasonable value of those services. The plaintiff's complaint that we haven't shown the court hourly rates or specific costs of the specific tasks in the time entry just don't make sense in this context. We did not bill Merrill Lynch by the hour. We did not apply hourly rates to any specific task or bill for any specific tasks. We've explained this all in my affidavit. Again, Rule 68 is designed to conserve judicial resources by encouraging parties to make good faith settlement offers and encouraging parties to accept them. It doesn't go away or become ineffective as the legal industry moves away from hourly billing. One of the plaintiff's other complaints is that Merrill Lynch's fees are unreasonable because they hired O'Melveny, me and my colleagues, we are in New York. And New York market rates are higher than Atlanta market rates. But recall, Your Honor, this case claims market manipulation on the New York Stock Exchange by Merrill Lynch, which is based in New York, and 3 other broker-dealers that are all based in New York. All of the evidence, the documents, the witnesses, all here in New York. It was not unreasonable for Merrill Lynch to hire New York lawyers to defend it, just as all the other plaintiffs did, by the way. Sorry, the other defendants. In addition, as explained in my affidavit, O'Melveny has a lot of experience in this area. We have been defending these naked short selling cases for over a decade, many of them brought by the same plaintiffs' lawyers here in other states. And by the way, some of those plaintiffs' lawyers are themselves here in New York. And we collectively have tens of thousands of hours of experience defending these suits. So not only do we really understand the regulatory environment and how the New York Stock Exchange works, but we know Merrill Lynch's operations. We know the people, we know the system. So while the average market rate in New York is higher than in Atlanta, it doesn't mean that the overall cost was too high for the value of the work performed. There are plenty of good lawyers in Atlanta, and some probably know this area or could obviously learn it, but they don't know Merrill Lynch. There was no get up to speed time in this case because I and my colleagues at O'Melveny know the facts, know the client. The standard is the value of the services performed. Merrill Lynch has presented detailed billing records of all the tasks we did and the time associated with those tasks. And we've put in a detailed explanation of the bills, the negotiations, the discounts, and what Merrill Lynch actually paid. We have proven that the Merrill Lynch fees we seek are reasonable based on the value of the services performed. I'll just repeat, because I've been defending Merrill Lynch and other Bank of America entities for years. They are highly sophisticated. Their goal is to pay as little in defense costs as possible. They drove down the total amount of fees for the case as much as humanly possible. Then when we went to do the fee petition here, at every turn, we attempted to be reasonable and conservative. Every time there was a path to choose what we should do, we picked the path that led to the lowest payment by the plaintiffs. We're asking nothing from the third-party discovery vendor or any of our other expenses. We're giving the plaintiffs the benefit of the full discounts. We're asking only for their pro rata share, even on those tasks that were exclusive to them. In the end, we are asking for $172,000 from 5 plaintiffs, 2 individuals and 3 corporations for 3.5 years of litigation that required briefing and argument on numerous dispositive motions, an appeal, and discovery. And we ask that you grant Merrill Lynch's petition in full.
No, I have a question. Typically in motions like this, we look at the hours and the fee charged and see how those fees were calculated based upon the talent that was employed to create them. And there's a calculus you can do that way. How do we do that here? I mean, you negotiated some sort of strategy. Your negotiation involves some sort of strategy involving some sort of quarterly fee. It's all very mysterious. So the fact that it was $172,000 and it was 3 years of litigation and there were a lot of motions, I mean, that's interesting, but it's not necessarily dispositive. Well, we did a lot of work, so it must be reasonable, you know? See what I'm saying?
I absolutely do, Your Honor. And there
help me out a little bit on that.
Yeah, there are 2 ways to as sort of a check on this. First of all, we have submitted our detailed billing records. They show that the total hours spent on this case, well, frankly, the total hours spent on the case during this period were 3,750 attorney hours. Now, Merrill Lynch is only responsible for a quarter of Rogers and Hardin. So if we take that out, I mean, it doesn't mean that it took them a fourth as much time. It just means we only have to pay for a quarter of it. But that's more than 2,000 hours of attorney time, which equates to $648 an hour, which is, my understanding, a perfectly reasonable rate in Atlanta. Mr. Laney can speak to that if you have questions. But the other thing is the evidence of the steps that Merrill Lynch took to keep its costs down, the negotiations, the discount, that arm's length bargaining, the willingness of a third party, not knowing it was going to get reimbursed, the willingness of Merrill Lynch to pay these fees in light of all the evidence that Merrill Lynch doesn't overpay, that in and of itself shows that the dollar figure was reasonable for the tasks performed. And of course, again, you have the detailed billing records that show the thousands of hours that lawyers put into the tasks that we've described.
All right, thank you. Who's up next?
Your Honor, Jimmy Paul, and I'm ready to go forward.
All right.
My plan has been to call Mr. Christian briefly, call Drew Green, and then go to the argument. I think my thought is probably to defer calling Mr. Christian at this point and go forward with calling Ms. Green for her testimony and then go into another argument. So. I'll move out of sight, maybe, but I want Ms. Green to sit so she can be seen when she testifies. I swear to witness. You swear testimony about the years of truth, all truth, and that's the truth.
Yeah.
All right. State your full name, please.
Drew Vanderveer Green.
All right. And let's talk just a minute about your education and your history and practice.
I graduated from the University of Georgia in 2005, degrees in political science and biology. I went to Emory University School of Law and graduated in 2009. I started working at this firm in 2010 with Mr. Paul in 2011. And in terms of this case, I've been involved since 2012. We weren't involved in the original complaint, but we got involved immediately after it was filed. I was involved with the removal action, the subsequent remand, many motions to dismiss, and the briefing involved in that, preparing for oral arguments, the number of appeals, the appeal and the cross appeal, the post-appeal briefing, and all the discovery issues, motions for protective order up till today.
Have you, I assume you've done research related to Georgia law and attorney's fee litigation?
I have in response to the motion.
Have you reviewed the affidavit of Ms. Rudson?
I have. I reviewed the affidavit and more specifically the 43-page set of invoices, timesheets.
And did you study the 43 pages of timesheets attached to Ms. Rudson's affidavit?
I did, every line item.
And after you reviewed the 43 pages, did you take any action in relation to this hearing?
Yeah, so I reviewed first the the timesheets. And then, I mean, it's a long procedural history, as we've just talked about. So I reviewed the dockets. In this case, I reviewed the appellate court dockets, and I tried to create categories with these color blocks that are in Exhibit 3 that we submitted yesterday afternoon, and see what might not relate at all to the Utah plaintiffs, the defense of the Utah plaintiffs' claims, and also what was completely indistinguishable from the Georgia plaintiffs' claims or other non-Georgia plaintiffs who aren't the Utah plaintiffs.
Well, let's take just a minute. Look at Plaintiff's Exhibit 3, please. Do you have that?
I do.
Your Honor, I would like to state an objection. Your Honor set a deadline for filing a response. And as you wrote in your order yesterday, the reason you set a deadline was so that Merrill Lynch could be prepared to address their objections. We received this exhibit at 6 p.m. last night. I'll just tell you that in New York City, we still don't go to the office. I don't have the ability to print that exhibit in my apartment where I'm standing in my kitchen. I don't think it's appropriate that they can go through now an exhibit that they hadn't previously presented and go through line by line when I can't even follow along.
Paul?
Your Honor, we've taken their document and we have analyzed their document, and we briefed in our briefs that the court allowed to be considered as a response that there are large amounts of time that are unrelated to Utah plaintiffs, and from the time records, there are no way to segregate or distinguish, as Georgia law does require, between items of expense that are unrecoverable and items of expense that are recoverable. And the cases go straight down the line on looking at this time capable of segregation to capable of distinction. And we argued that in our motion and cited the cases, several of the cases that make that point. And so that was one of our points. And I think we are certainly enabled to confront Merrill Lynch with our analysis of their own documents and the manner in which they have come up with $172,000. So it's directly relevant, and it's no surprise to them about their own documents and about the position that we asserted in the papers that we did file.
Ma'am, is there something you wish to say?
Yes, Your Honor. We obviously read their response. We understand that they made a general argument that you couldn't segregate out certain time entries. Although, of course, as I said, they actually misrepresent that in their response. That's not the same thing as actually pointing to any entries in particular. As I said, I can't even look at the document they're asking Ms. Green about unless I guess I could turn off my video and try to follow along on my computer. I don't understand the basis for why they sent this over at 6 o'clock last night. They've had these records since January, over 2 months ago. So the fact that they gave notice that they were going to generally make this argument does not relieve them of their obligation to provide us the chance to respond. At the hearing, I can't even follow along.
I understand. I'm going to allow it, and if it seems appropriate that you need time to file a response to that, you can. Go ahead.
Thank you.
And if you want to look at it, Exhibit 3, please. And I'll ask you the question so that you will stay as brief as you can. Did you personally review every page of Exhibit 3?
I did.
Did you personally put the green marks on Exhibit 3 where they appear?
I did.
And what was the purpose of green marks based on your analysis and your judgment?
The green marks, to the best of my ability to discern what the entry was related to, that category was for time entries that were unrelated to defending the Utah plaintiff's claims or time related to defense of the Georgia plaintiff's claims or the non-Georgia, non-Utah plaintiff's claims that might have been lumped in with the Utah plaintiff's claims.
Did you also decide to use yellow coding for some of the entries?
I did. The yellow coding was to represent time entries that were vague or you couldn't actually determine what work was performed. And so those are in yellow.
And then red time, what is the basis of your red coloring in the color-coded document Exhibit 3?
The red coloring relates to any time after the September 18, 2015 voluntary dismissal of the Utah plaintiff's claims.
And what is the basis on which you made the red marks for time after the Utah plaintiffs had already voluntarily dismissed their claims?
Because the Utah plaintiffs weren't pursuing any claims, they weren't filing any motions, they weren't participating in discovery. After that time, up through the entry of judgment, there wasn't any activity directed at the Utah plaintiffs directly, from what I could see, other than, I think, research on forcing the Utah plaintiffs into arbitration, which wouldn't be related to this case. So that's why I put it in red.
Your Honor, I plan to go further, but I'll tend to Exhibit 3 at this point.
Very good.
All right, let's turn to the green color code first, please. The green color code, you determined from your own judgment and analysis was work unrelated to the defendants opposing the Utah plaintiffs, correct?
I did.
Right. Now, take your time, and we'll go question by question, but go ahead and focus on the points, the substantive points that you decided were not related to the Utah plaintiffs, and then explain how you came to the conclusion to color those green.
Well, so I looked at all the motions to dismiss that were filed and focused on the omnibus motion to dismiss that would have dealt with both Georgia and non-Georgia plaintiffs' claims, and any time that would have related to those, and tried to look through them. I looked at the omnibus brief, the response briefing, the cross appeal related to the Georgia plaintiffs' claims that would not be related to the Utah plaintiffs' claims that would have been dealt with in the opening appeal that the non-Georgia plaintiffs filed dealing with Lex Loci. And then, so that was one chunk that dealt with the motions to dismiss. I didn't include any time for the motion for reconsideration because the non-Georgia plaintiffs filed that to deal with Lex Loci issue and the public policy exception and that stuff. So I specifically did not include those in the green. I was trying to focus on one time entries that I could determine were almost always related to the Georgia plaintiffs' claims. And so I looked for references to the cross appeal, any assistance with, there were assistance with preparation of the non-Georgia plaintiffs' appeal that Ms. Rudson did argue. And I didn't include those in the green entries. So there's one chunk of time that is marked in green that relates to the motions to dismiss and the subsequent appeals to the extent they're unrelated to the Utah plaintiffs' claims. And there's another set of time that deals with motions to amend the various complaints or to add certain parties. And there are specific references to Colorado plaintiffs and other plaintiffs that absolutely don't relate to any defense of the Utah plaintiffs' claims. Those were also included in the green markings. And there were references to preparation of budgets that also I included in the green because I can't tell how it relates specifically to defense of the Utah plaintiffs' claims.
Did you total the time for lawyers related to the entries that you have colored green?
I did.
What
To
are
the best of my ability. 112 hours approximately
for attorneys?
For attorneys.
And what about paralegals?
Approximately 8.5 hours to 9 hours.
Are there any hourly rates shown anywhere on the timesheets?
Nowhere.
Or at any time hourly rates shown anywhere on the one sentence bills that are attached as Exhibit C to Ms. Rudson's affidavit?
No.
Are there any hourly rates shown for paralegals?
No.
Is there a way to tell from reviewing Exhibit 3, that is the 43 pages, and Ms. Rudson's Exhibit C, her one sentence bills for quarterly billing, is there a way to determine what is the dollar amount related to what you colored green as unrelated work that ought to be eliminated and put away somewhere? Is there a way for you to know how much money that is?
No, I can't. From
And
review
why,
of the,
and why is it?
because there are no rates attached to any attorney or any paralegal. And I can't assign a value to any of the time entries because I don't have rates.
All right. Now, is there a way to segment or distinguish between the amount charged by Merrill Lynch for work related to Utah plaintiffs and the amount charged by Merrill Lynch to do work unrelated to the Utah plaintiffs? Is there a way to segment that as the Georgia case is talking about?
Not that I can see from review of the 43 pages of this timesheets.
All right. Let's go next to the yellow color, please. And this is not a large block of time, but just talk briefly about what is the reason that you put yellow coding on. I think it was 28 hours, but we'll get to that.
So as I was reviewing the timesheets, there are a number of mostly 0.1 time entries for receiving email. And it looks like it's from an automatically generated type email from the listserv when something is filed in this case. And they're primarily entries of Andrew Frackman, who's another partner with O'Melveny. And so there are a good bit of those where I can't tell. I can see that you received an email, but I can't understand the work that was performed. And I can't link that receipt of an email to any work done to defend against the Utah plaintiff's claims. So it's just vague. There are other entries that also relate to the budget where I can't tell because they're vague if they relate to work defending against Utah plaintiff's claims.
And did you total the lawyer hours that were colored yellow?
I did.
And how many hours?
28 hours.
Again, were there any hourly rates available on either the bill itself, the one sentence bills, or the 43 pages?
No, there were not.
Was there a way to segment out and set aside the charges that relate to descriptions which cannot be allocated physically or mentally to Utah plaintiffs?
Not based on review of the timesheets.
Let's go to the red color code. What was the date that the Utah plaintiffs voluntarily dismissed their claims here in the Georgia case?
September 18, 2015.
And so what was the start date for the red coloring that you did on Exhibit 43?
The 21st of September 2015 through April, 8, 2016.
And the cutoff date was for what reason?
That was the day of the entry of the judgment.
During that time, looking at the entries that you colored red, is there any time that could reasonably be allocated or related to the Utah plaintiffs after they voluntarily dismissed that claim?
Except for one entry that I saw related to research about forcing arbitration of the Utah plaintiff's claims, which I guess would apply in the Utah appeal. That was the only reference I saw to the Utah claims.
Did you total the hours of lawyers that you colored red because they were after the time that Utah plaintiffs voluntarily dismissed their case?
It's approximately 185 to 190 hours of attorney time. And mostly, that's mostly partner and counsel time.
And what about paralegals?
8, approximately 18, quite 18, yeah.
All right. Now, was there, going to the Georgia cases on segregating or distinguishing, based on the 43 pages of timesheets, is there a way to carve out and somehow segment the time that is colored red and know how much money should be segmented and eliminated from the scope of the universe of time that Maryland is still probation on?
No, not without the billing rates, not based on the timesheets alone.
Have you totaled the total hours that were colored green, yellow, and red, the total lawyer hours?
Yes.
What is that total?
Approximately 330 hours.
All right. And what about paralegals? Did you call those? Did you total those?
I did approximately 18 hours.
Donna, she will leave her with Ms. Rudson if she has questions on those.
Yes, thank you. So, Ms. Green, I'd like to start with just the category of the vague entries for a minute to respond to Mr. Paul's argument that we were put on notice that this was a complaint the plaintiffs would raise. Can you point to anywhere in the written response the Utah plaintiffs filed that made an objection that time entries were too vague? Because I can tell you, I just searched the PDF and it doesn't contain the word vague.
Not without it in front of me.
Do you have access to it on that table?
I probably do.
I can probably get it for this is my work copy. I don't think it has notes. My work copy's got notes. It doesn't relate to your question, but I can let her look at it.
I'm just asking Ms. Green to look at it. I'm not asking you to put it into evidence.
Yeah, that's fine.
Well, we set out what the standard is to obtain an award of attorney's fees, which includes what must be shown. And that Merrill Lynch attorneys haven't attempted to comply with Georgia laws to obtain an award of attorney's fees, which would include meeting that standard under 9/11/68 or 9/15/14. It's on page 5. Law cited on page 6. We say that the 43 pages of time entries attached to Attorney Rudson's affidavit do not show a single dollar amount related to 43 pages of extensive time entries by Attorney Rudson, Frackman, or other attorneys, as well as paralegals. Not one single time entry is related on the billing sheet to any dollar amount. I think that's vague. The word vague may not be in here, but that's my description of not being able to discern what work in a single time entry is actually linked to the Utah plaintiff's claims, the defense of those claims. And I think that we laid that out in page 7.
Well, let's just be clear about this, because we agree, and as I said this in my opening, we didn't bill Merrill Lynch by the hour, so there are no hourly rates and there's no dollar amount associated with any task. But that's not the basis for your yellow highlights, right? Because that would apply to the whole bill.
Ask the question again. Sorry, I don't understand.
Sure. You just, when I asked you to explain where the plaintiffs had made this objection previously, you pointed out that the lack of billing rates and dollar values for specific tasks was stated in your response. And I'm saying, but that's not what the yellow highlighting is for, right? Because that's the case for every single time entry on the bill.
The yellow highlighting is for entries where I cannot tell if the work performed, because it is vague, relates to the defense of the Utah plaintiff's claims. And I think that we laid out the standard and said that we couldn't make any of these links. Now, the fact that I'm using the word vague might be, a take on, you can't link the work done to the defense of the plaintiff's claims, Utah plaintiff's claims. But that's the basis for the yellow coloring.
Okay.
And like I said, it's 28 hours out of the other chunks.
Fair enough. And you understand that Merrill Lynch is seeking only 12 or 13% of those 28 hours, right? So we're talking a few $1,000s maybe.
That's what you've argued.
Yeah, but you understand that's,
I
you've
understand.
read this, that's what we're seeking. Okay.
Yes.
If we could turn to the green highlighting, please.
Yep.
You just testified under oath that the green highlighting is for entries that are unrelated to the Utah plaintiffs. Is that correct?
It is, to the extent, to the best of my ability to discern what is in these time entries. I took these time entries, pulled out the dockets, pulled out the appellate court dockets, and tried to make sense out of, so for example, the cross appeal that related directly to the denial of the motion to dismiss on the Georgia securities fraud claims. Those are not related to the non-Georgia Utah plaintiffs' claims that were appealed by the non-Georgia plaintiffs in the related but separate appeal. So I went through and attempted to take out that time, or if something related to an omnibus brief that would have dealt with all the claims where I couldn't distinguish, or I couldn't parse out that it specifically relates to a Utah defense of a Utah plaintiff's claims. That's how
Okay, so if we could look at some of these entries, please, that you have testified under oath are unrelated to the Utah plaintiffs. And if you could turn to the bottom of page 3 of the exhibit, please.
Okay.
There's a time entry there for me on March 13th, 2013. Review and edit revised draft omnibus motion to dismiss. Is it your testimony under oath that the omnibus motion to dismiss did not relate to the Utah plaintiff's claims?
I said that it's either unrelated or it's indistinguishable from the Georgia plaintiff's claims.
Well, let's be clear. The exhibit has a legend at the top. I'm sorry, I didn't hear you.
I object to the lawyer cutting the witness off in the middle of a sentence, please.
Well, then I apologize. But if you could focus your answers on my actual questions, please. And I'll ask you to look at the legend that you and the plaintiffs have put on the document where you describe what green means. Do you see that legend?
Yes.
And it says unrelated to Utah plaintiffs, correct?
Yes, and I'm explaining to you.
I don't need an explanation. Thank you. I'm just asking you to answer my questions. And so if we could go back to the bottom of page 3, the entry on March 3rd, 2013. Tell me how you think the omnibus motion to dismiss is, quote, unrelated to the Utah plaintiffs.
I think that the portions of that brief that are unrelated to the Utah plaintiff's claims are unrelated, but I can't tell. And I'm explaining to you the legend, a shorthand legend, so you can see what I've tried to mark and sit here and testify to you about what went into trying to go through these entries. I am trying to say that that notation, the green, means unrelated to the Utah plaintiff's claims defense, or just something I couldn't parse out from the other claims.
Okay, so when the legend says unrelated to Utah plaintiffs' claims, and when you just testified that this was unrelated to the Utah plaintiffs' claims, what you meant to say was entries that you could not tell for sure were in fact related to the Utah plaintiffs' claims.
Yes, and I tried to explain that one.
Okay. Well, you can see why I was confused with the legend saying unrelated to Utah plaintiffs' claims. That's just not accurate, right?
The green marks are either unrelated to Utah plaintiffs' claims in one way or another.
Well,
I tried to explain.
The legend says unrelated to the Utah plaintiffs' claims. Tell me how the omnibus motion to dismiss was unrelated to the Utah plaintiffs' claims.
Portions of the omnibus brief go directly to the Georgia plaintiffs' claims for securities fraud and violations of the Georgia Securities Act of 2008. Those are not related to the Utah plaintiffs' claims. So I'm saying that this may be a shorthand notation, but I cannot discern from your entry, okay, so this amount of time relates to the Georgia Securities Act claims defense or dismissal, or this relates to some lex loci argument.
Okay, the Utah plaintiffs asserted claims under the Georgia Securities Act, didn't they?
Off the top of my head, I can't remember.
Well, I'll tell you that they did. So I'll ask you to explain how you concluded that
Well,
a motion.
I think let's move on. I get the drift.
Okay, thank you, Your Honor. I just would like to note that all of the motion to dismiss was directed at the Utah plaintiffs' claims because they asserted the same claims. I'd like to quickly turn to the red highlights, Ms. Green.
Yep.
Now, you testified that everything after the Utah plaintiffs filed their notice of voluntary dismissal without prejudice had nothing to do with the Utah plaintiffs, right?
I testified that the red was to note all the time that was after the voluntary dismissal.
And you said that after that date, the Utah plaintiffs had nothing to do with this litigation. They filed nothing. That was your testimony, right?
I said they weren't prosecuting any motions. They're not participating in discovery. There's a lot of time in here. It's a bunch of discovery that they weren't participating in. There was a reference to arbitration of Utah plaintiffs' claims.
Right. I'm just focusing on it. If you don't remember it, the transcript will show.
I object to the lawyer continue to interrupt the witness in the middle of a sentence.
Well, I'd like the witness to actually just answer my question. This is cross-examination after all.
Okay,
So,
hold on a second. All right. Ask the question, live with the answer, and then if you need to follow up, go ahead. All right.
Thank you, Your Honor. So, Ms. Green, the transcript is what it is. I guess you're saying that you don't recall testifying under oath that the Utah plaintiffs filed nothing further after that date in the red area. Is that correct?
There may have been
I'm asking about your testimony, Ms. Green.
Motions that were filed.
I'm asking about what you said.
I don't remember saying that they filed anything. I say that they weren't prosecuting motions. They weren't participating in discovery. They filed the voluntary dismissal. I guess their motion for judgment under Rule 91168 was pending. We could have filed a responsive brief, but affirmative action taken by the Utah plaintiffs in terms of motions. And I'm only 37, but my eyesight might be bad, but I thought I'd only seen something related to the arbitration and no affirmative motions and no discovery directed to the Utah plaintiffs specifically.
Okay, so I just have a couple more questions. The notice of voluntary dismissal that the Utah plaintiffs filed was without prejudice, right?
I believe so.
Which means they could have come back into the litigation. They were still parties here, right?
I believe so.
And do you recall that the defendants filed a motion for final judgment against the Utah plaintiffs, and the Utah plaintiffs opposed that motion?
Yes.
And that was in the red area, right?
Yes.
Okay. So there is time in what you put as the red area that's not only directed at the Utah plaintiffs' claims, but effectively directed exclusively at the Utah plaintiffs' claims, right?
Defending against a motion for judgment after you've already voluntarily dismissed, I don't think is us prosecuting our claims further.
Thank you for that. My question is a little bit different. There is time billed to the matter in the red area relating to the Utah plaintiffs' claims, correct?
Relating to there could be for the motion for judgment that you just referenced, there could be a defensive pleading, and there is also a reference to Utah in terms of y'all trying to force the arbitration in the Utah case and the appeal in the state of Utah.
So the time spent in the red zone on seeking final judgment against the Utah plaintiffs, I'm not understanding why you put that in the red zone if you're trying to imply that that doesn't involve the Utah plaintiffs. Could you explain?
I'm saying that they voluntarily dismissed on the 18th, and the time after that is just after they had tried to get out of the case, after they had filed voluntary dismissal. Of course, they're not. You have to oppose a motion for judgment. That's not us affirmatively pursuing the claims any further.
Okay, so in your review of the case law, is there any case that suggests that the party entitled to its attorney's fees under Section 68 does not get its fees through final judgment?
As I sit here today, I'm not aware. I'm not saying that there's not one out there, but I'm just not aware.
Okay. I don't have anything further, Your Honor, but we would like to put something in writing on this after the hearing.
Mr. Paul?
Yes, I'll return to the argument now. Your Honor, the first point I'll try to make is that the attorney fee motion filed by Merrill Lynch does not establish a way to determine reasonable attorney's fees and expenses related to defending the claims of the Utah plaintiffs. On the front end, and I may can be corrected, but we have done as hard a search as we can do. And we have not seen any reported decision in Georgia that is awarding attorney's fees based on a proration of statistical analysis that is not tied to actual time defending the case, hours spent defending the case, and the market rate for them, and the overall question of necessity and reasonableness. And so there's nothing in taking $1.3 million of claims of hours, $1.3 million of dollars, not measured by hours, not measured by rates, and then take a mathematical proration based on how many are you, and come up with something that has no relationship to tying $172,000 to specific time at specific rates with questions of necessity and reasonableness. And so we think that the code section 91168 talks about, recover reasonable attorney's fees. The court's order, it said reasonable fees related to obtaining the dismissal of the Utah plaintiffs. And Fiat Auto case says attorney's fees unauthorized if they fail to prove actual cost of attorney's fees and the reasonableness of the cost. And what we say is taking a universe of time of dollars, not tied to specific time, and prorating that on a number. If we'd had 100 plaintiffs, we would have gotten 5%. If we had 20 plaintiffs, we get 25%. And so we say there's no time entry that's got any dollar amount. There's no hourly rate. Ms. Rudson tried to talk about hourly rates based on a mathematical analysis, which is not her testimony. That 648 hours is the market rate in Georgia for doing this case. And Mr. Sinkfield's at the top of the pile, and he ought to get what he gets. King and Spalding, Austin Bird, Sutherland Brown, Kilpatrick, all of them will get the top of the market. But the question is market, not just dividing up hours into time and saying, well, okay, 648 is good. And so we say that on the first point, if you look at the bills, excuse me, not bills, if you look at the time records, there's no way to look at the time record and then look at the one sentence bills that are billed each quarter for work not yet done. There's no way to look at the timesheets and estimate billing for future work that's not yet been done and tie those time records or those payments to, okay, what was the cost of doing this to the Utah plaintiffs? What was the value added to Merrill Lynch with these plaintiffs? It can't be done. And it's not done under Georgia law. And to repeat, there's no case that we can find a reported decision in Georgia where the judge has said, okay, just prorate it. I haven't seen a federal case. I don't know who the judge is. I don't know where the judge is, but it doesn't matter. I'm not going to get into a talk because she's not cited that case as far as I know, except now. But that's not Georgia law to prorate. So there's nothing in Ms. Rudson's affidavit that attempts to establish personal knowledge of market rates in Fulton County or in metropolitan Atlanta in state court. And so the proration system, we say, doesn't get there, and it doesn't satisfy the Georgia requirement to show the cost. Was it necessary and was it reasonable? Did it add value? Was it necessary and was it reasonable? So we say that's a front end issue, and it's obvious, but it's true that there's no way to meet the Georgia rule on cost and value. The next point we'd like to make is that the Merrill Lynch 43 pages of time make no attempt to segregate or distinguish between fees that are recoverable because they relate to Utah plaintiffs and the dismissal of their claim, and unrecoverable fees related to things that do not relate to the Utah plaintiffs. And so we cited in our papers, Canton Plaza against Regions Bank. Regions Bank got sued for wrongful foreclosure. Regions Bank counterclaimed against the borrower for attorney's fees on a loan document provision. Regions Bank won the wrongful foreclosure case. It put in for its fees, and the court denied the fees on the grounds that the court cannot tell from your billing statements whether the time entry relates to your defense of wrongful foreclosure or your time relates to your attempt to get attorney's fees because of the way your bills are. They cannot be severed, and you can't look at them and say, this body is $50,000, I'll carve it out and look at the rest, and it's $20,000, and you get it. Couldn't do it. So Regions Bank lost. The other case we cited to the court was Citadel. We cited several Citadel, also contractors. Citadel was a contractor. He contracted with a developer. The contractor sued the developer on the contract. The developer counterclaimed, as they always do. Citadel then filed a third-party claim against the roofing contractor. It won its claim to get money out of the owner. It lost its claim to get attorney's fees and against the roofing contractor on an indemnity agreement. And the reason was because the jury that tried the case gave no attorney's fees, and the Court of Appeals affirmed because they said, you know, contractor, you've got lawyer fees on suing on the contract, and in the very same bill, you've got lawyers' fees dealing with the third-party complaint, and there is no way to sever those because the way your bill is, your timesheets are not sufficient to say, cut out the third-party claim, leave the fees that you spent on the contract claim. And that's the point I was making in the direct examination of Ms. Green, and that's the point I made at opening. These bills do not allow separation of time in the way that they're done, particularly with no hourly rates and no time tied to rates and no time to hours. And the 1 cent bills for future work aren't tied to anything. The estimates aren't produced, if they exist, that is discussed in Ms. Rudson's affidavit. And they're just a 1 cent bill for $228,000 for the next 3 months or something. And so there's nothing that allows the court to separate fees that are recoverable from fees that are not recoverable on the proration theory that was followed here. And we cited the cases that talk about that point. So you've got the green time of 112 hours, and you've got the yellow time of 28, and you've got the red time of 190 hours. 190 hours in the red, and the only thing in the red that relates is when they finally filed for the motion to get a final judgment. Yes, there was a brief file. That's it. That's it. And there's, so we say that all of that time is so integrated, and because of the way it's done with no hours and no rates and nothing tied to time, you can't separate it. And so Georgia law does not allow fees to be awarded on a piece of a case when the pieces of the time aren't separated from the rest of the pieces of time. And that's the way these bills are, because they're not real bills of, with hourly rates. The next point I will go to is the statistical analysis. And what we say is that if you look at the billing process here and then look at the statistical analysis, there's no way to tell the cost for the services rendered by O'Melveny to obtain a final judgment dismissing Utah plaintiffs. And there's no way to tell the value based on the way the bills are done. Let's look. Ms. Rudson says in our affidavit, we don't bill on an hourly basis at hourly rates. That's traditional. She just got through arguing. This is a new way. That's fine. It's a new way. We're going to negotiate. There are contingent fee cases in Georgia that some lawyer negotiates when the red light got run. But the fee awards on a contingent fee are hard, and they are unusual because the courts are saying, wait a minute, just because you get 40% on a red light case and you get $100,000 and you file a complaint, doesn't mean you get $40,000 on the red light case. And there are a few cases that do go into market exploration of contingent fee cases, but this is not a contingent fee case. This is a case with a contract with a client that provides what I'm about to talk about, and that is that under Ms. Rudson's affidavit, every quarter, Merrill Lynch apparently gives O'Melveny gives Merrill Lynch an estimate of fees, not for work already done, because that's paid, but for future work. Her affidavit says that about mid-quarter, Merrill Lynch will pay the invoice. That's for work estimated, not yet done, and it's not clear what's been done and what hasn't been done. And so the payments aren't related to any work, period. The payments are related to estimates of future work. And then the money goes, to O'Melveny, and it's not tied to time. It's not tied to service. It's not tied to anything. It's fine. It's a negotiated deal, but that doesn't mean that you can do that and get an attorney's fee award on a piece. In Georgia, if the court looks at the bills, you can see the quarterly bills are Exhibit C to Ms. Rudson's affidavit. And so just for the December 7, 2012 invoice is for all of December and all of January 2013. The September 6, 2013 invoice is through October. The November 25, 2013 invoice is for November, December, and January, 2 months in the future. The February 24, 2014 invoice is for February, March, and April 2014 in the future. The September 4, 2014 invoice of $90,000 is for September and October, that is in the future. And so this is a lump sum, one sentence bill for future work, not tied to any specific work that has been done, and most of the time paid in advance of work. And there is not a way to take those payments on an estimation for future work that nobody knows whether the estimate had anything to do with Utah plaintiffs or what it had to do with, and it's not ever tied to the actual work that was done. And so Georgia law requires the showing in the fiat case that I mentioned, but in all the cases that you've got to show cost and you've got to show it's necessary, got to show it's reasonable. You can also show value, both, and show it's necessary and reasonable. But this is not that. And this is a system that is even less applicable than a contingent fee case on a red light. It is one case, and yes, it's a red light case, and it's one plaintiff. This is a multi-plaintiff, multi-defendant, multi-claim case with a universe of money and a proration of a universe of money. And we say that that there may be a way that Merrill Lynch could have done it, but we say this will not do it. And it's not like the Utah plaintiffs tried to stiff Merrill Lynch. I mean, they contrary to 2448, they dumped the full bills instead of the unredacted, I mean, the full settlement instead of the redacted settlement versions. And it's directly against 488, but it clearly shows that these Utah plaintiffs were not trying to run away. There are strong offers that were made, and the redacted versions that we filed show that Merrill Lynch was tying settlement to dismissing the Utah claims that are still pending right now. And that's why I was going to call Mr. Christian just to let him say it, but I don't, but given the presentation so far by Ms. Rudson, I don't want to bother Mr. Christian. But the time of dismissing a Utah case that's still pending in order to get peace on Georgia attorney's fees is not only outrageous, it makes it impossible to settle. And so, having said that, the papers they filed clearly show that the plaintiffs weren't trying to run away here, but they couldn't ever get there, and they shouldn't have to get there under the law. And so, for these reasons, we say, based on the evidence on their own bills, one sentence bills, the payments of the one sentence bills for future work unallocated, the timesheets that don't have hourly rates, the complete absence of any tie of work to money in terms of tangible work to tangible money is a situation that the plaintiffs didn't create this. Merrill created this. Merrill created it. And after the fact, they did their proration. But we say that does not get them there under the Georgia law. And for that reason, we think the award ought to be denied. If the court wants to deny it without prejudice, I mean, it's not like we're trying to run away here, but there's no basis that they ought to get $172,000. There's no basis they've got any less amount that they should get on their records, because their records do not get there under Georgia law. And so we ask that the motion be denied if the court thinks without prejudice and give them another year. But I don't believe that the few cases where people have had to go back, right? Sometimes the Court of Appeals will remand and say, all right, go do the evidentiary hearing you should have done in the first place. And so it goes back. But I don't think I've seen but one case where they said, all right, I'm going to deny these, but I'm going to give y'all, 30 days to come back and do it right. Okay. But there's some that they said, no, you can't do it right because you didn't do it right to start with, and you can't just keep helping yourself. So we're not trying to get ahead of them, but we don't think there's a basis in law to award fees here. We think it ought to be denied either with prejudice or without prejudice. And if they without prejudice, they get to have another run, and it costs everybody another ton of money. So with that, we conclude.
Mr. Fall, you do agree, though, that there are claims that are common to all defendants that were made by plaintiffs, yeah?
I'm sorry, I couldn't hear.
You do agree that the plaintiffs made claims against certain claims that applied to all defendants. Is that right?
To all, yes, sir. If the question was, yes, if I understood you right, yes, I agree that plaintiffs file claims against all defendants. I may not have heard you right, but yes.
No. I mean, in other words, if there were 15 claims made in the case, some of them applied to all defendants.
Yes.
Yeah. Now,
Yes.
as to just to walk me through this, let's suppose that there are 5 claims in the case, and they are claims that apply to every defendant in the case. And the defense prevails and is awarded fees. You'd agree that in that case, the plaintiffs would be responsible for the fees, even though they were made against all defendants. And there were other plaintiffs as well in the case. Maybe I'm not stating this right. I'm trying to come up with some way of understanding what to do in this case where we've got several groups of plaintiffs, different defendants, and what happens when there's a fee award, and we're trying to find out how to allocate, if you can, in a case where the liability is common among the group. You follow me?
Yes, I think so. The 2 cases that I cited were cases where there were claims, the contract to sue the owner, and then the contract to third party, the roofing contractor, and then the owner counterclaim back. So a claim, counterclaim, third party claim, and defense. And could those have been done in a way that the fees that the contractor was entitled to get for defeating the owner's counterclaim? Could the billing been done in a way that that person could get those fees, even though he did not get fees out of the roofing contract? The answer is yes, he could have. The contractor could have billed it in a way where it was severable, and that's what these cases talk about, is can you take the universe of time and sever it? And in that case, they could not, and that's why the guy couldn't get fees. In this case, it can't be severed the way it's done, but it's not, it is, I think, true that if you've got multiple plaintiffs and multiple defendants, and somebody is going to try to get 9/11/68 fees, it can probably be done in a way that you can show the cost to the client and the necessity and the reasons. I think you can do that. But I think you've got to do it. And I'm not trying to play I got you. I just don't think this is the basis in Georgia. Under the present code and the present case law, I do not believe it can be said that, okay, you got 39 plaintiffs and some of them went away and you end up with 20 plaintiffs. And so you're 5 with 20 or 5 with 39 or 5 with 28 or whatever. And so a reasonable way is to parcel it up pro rata, because this is not a pro rata case. I mean, this is a case where people have got different in it. So,
let me try it this way. There are claims in the case where the Georgia plaintiffs and the Utah plaintiffs are both asserting the same claim against the defendants. Is that correct?
Initially, yes.
Yeah, okay. So when it's time to award fees because the defense recovered an award against the Utah plaintiffs, how would you parcel out the fee responsibility? Because the defense work is common, whether is common to both plaintiffs. How would you say, well, I can only charge you half, or I have to charge them? I mean, you see what I'm saying? What do you do there?
Yeah, yes, I think so.
Would pro rata work in that context? Wouldn't pro rata be appropriate? Or would you
Yes.
simply say no? That if you get the award and the time was spent and it was common to two sets of plaintiffs, the award is taken against Utah. They could get the entire award against Utah. Does that make sense?
Yes, I think.
How would it happen?
I think in this situation here, the Georgia plaintiffs were never the same as the non-Georgia plaintiffs. And so the work that was done against the Georgia plaintiffs is a situation that we don't think can be charged against the Utah plaintiffs. They had different cases, and the court threw the Utah case claims out, and we tried Lex Loci and tried other things, but they were all in a different position. So it's a different. But yes, I think there are. I think class action.
Right, I get it. I understand. Thank you. I understand what you're saying. It is applied to this case. Thank you.
I'm sorry.
I'm sorry. I'm talking. I'm not talking to myself. I promise. No. I understand. I understand your point.
Yes.
Thank you. Thank you.
I have nothing further, but
Neither do I.
That's the question. Okay.
And I guess it's my turn.
Yes, it is.
So the statute says that Merrill Lynch shall be entitled to recover reasonable attorney's fees and expenses of litigation that were incurred by Merrill Lynch from the date of the rejection of the settlement offer through the entry of final judgment. And as you said, Your Honor, that could mean, as the 11th Circuit says, that we get everything that relates to their claims. The plaintiffs seem to say you get nothing unless it relates exclusively to our claims. And to us, reasonable means you do a pro rata allocation. Now, Mr. Paul repeats and repeats that we don't have billing rates or dollar values assigned to specific tasks in the bills. That's true, but that has nothing to do with the allocation issue, because the plaintiff's complaint is that if we have an entry, 2 hours spent drafting motion to dismiss claims of non-Georgia plaintiffs, for example, it doesn't matter whether there's a dollar value or a billing rate. Their point is you can't tag us for that because it doesn't apply exclusively to us. This is laid bare by Ms. Green's testimony that entries that relate to the omnibus motion to dismiss can't be on their dime. And Mr. Paul just repeated that the Georgia plaintiffs were never the same as the non-Georgia plaintiffs. That's simply not true, Your Honor. All the plaintiffs as a whole pleaded all the counts of the complaint. We moved to dismiss the non-Georgia plaintiffs' claims on the grounds of Lex Loci, but we also moved to dismiss them on the grounds that they hadn't pleaded their claims. And again, as I mentioned, the Lex Loci motion was directed only at the statutory claims. The other motion to dismiss was directed at the statutory claims and the common law claims. It is how we got the Utah plaintiffs' common law claims dismissed. So the notion that that briefing has nothing to do with the Utah plaintiffs is just false. Mr. Paul really seems hung up on the we didn't bill by the hour, there are no hourly rates. That is not the test in Georgia. The Georgia Supreme Court held in Georgia Department of Corrections versus Couch, quote, the party seeking fees must also introduce evidence of hours, rates, or some other indication of value of the professional services actually rendered. We do not have to put in evidence of hours or rates. We have to put in one of the three things. And we did. We put in evidence of the indication of value. And that evidence is the time records of all the work that we did and the negotiations with Merrill Lynch, all the ways they tried to bring down their legal bill and the fact that they paid it. That is evidence of value.
Well, wouldn't the evidence of the hourly rates of the people that work the file, wouldn't the evidence of the hourly rates of the people that work the file play a role in determining whether or not your fee formula was a reasonable one?
Yes, and as I explained in the affidavit, the quarterly fees are based on that to some extent. So Mr. Paul's argument that the fees are not tied in any way to time or service is not true. The way the procedure works is we would agree on a fee for the quarter based on an assumption about what the tasks will be in that quarter. How much we and Merrill Lynch agree for that quarter rests obviously on the assumptions about the tasks, but also what's the value of those tasks, and how do we determine that? We estimate how many hours those tasks take, and we think about lawyer rates. So it does go into the mix. It's just not separated out. And then what happens is we have a quarter where it turns out that maybe we didn't have to do what we thought we were going to do. So then the next quarter, the fee that's negotiated is lower. And this is shown in my affidavit, Your Honor, paragraph 24, when I list the quarterly fixed fees. There are 2 quarters in this period where we asked for no fixed fee at all, 0. And I'm pretty sure if you go back and look at our time records, you will see that we billed time in those quarters, but we didn't charge the client for it because we were truing up from the quarter before. That true up is done every quarter, and it is based on the actual time records and billing rates. But what it ultimately means for Merrill Lynch is they pay a lot less than our billing rate. And I'll just give you an example, Your Honor, just find my notes. As I said, the average billing rate equates out to $648. My billing rate in 2016 at the end of the period was $950. My senior partner, Andrew Frackman's rate was $1,175. So we're not asking for those rates. That's not what Merrill Lynch paid, and that's not what we're asking for. We're asking for reasonable rates, which is evidenced by the heavy negotiations between Merrill Lynch and O'Melveny. And again, all the other things. We're not asking for any portion of the discovery vendor's costs, for example. That's work that would have been done by attorneys at my firm. So I really don't see how $1.3 million for what is thousands of hours of attorney work is unreasonable. Mr. Paul's statement that these are not real bills, we gave you the time entries. We gave you the bills. They are tied to time. I would like to call Mr. Laney to address Mr. Paul's concern that there's no evidence in the record that this average rate of $648 is reasonable. Mr. Laney?
Thank you, Ms. Rudson. We, in this case, froze our rates at our.
To be honest, is he testifying or is he arguing? I can't tell.
I'm stating in my place, Your Honor.
That's fine. Go ahead. And
Yes.
to state in your place, I think you need to tell us a little bit about why you're qualified to do so.
All right. I've practiced law for more than 40 years, 35 years of it at least here in Atlanta. I'm a partner at Rogers and Hardin, where I've been a litigation partner since 1988. Most of my practice is in Georgia generally, and I'm familiar with how you establish rates with clients. I'm familiar with competing for business on behalf of clients, and I'm familiar with receiving pushback from clients with respect to rates. I set forth a lot of this detail in my affidavit.
All right.
I state my place merely to point out that the 2012 rates were the rates that Rogers and Hardin charged for the entirety of this case, even though our rates increased over time. So our fee petition obviously provides a cost savings for Merrill Lynch and thus for the Utah plaintiffs with respect to that item alone. But I rise to state in my place that our 2016 rate, by the time we got to 2016, Mr. Sinkfield's rate had increased by 21% to $795 an hour. By 2016, my rate had gone to $655 an hour. And Ms. Bennett, her rate had gone to $595 an hour. So all of these are an increase of approximately 20%. And I think that, in my opinion, $648 an hour is well within an acceptable and competitive hourly rate for the nature of this case for complex commercial litigation.
Let me ask you a question, though.
Yes, sir.
As it stands, just looking at the records that have been submitted, the $648 is sort of a hypothetical number, isn't it? I mean, it is an amalgam of what rates and whose rates.
Yeah.
And further, you know, when you sit down and you do this monthly estimate as to what we're going to, or quarterly, whatever, how do you calculate that? I mean, do we, what rate do you calculate? How does that happen?
Here's how it happens, Your Honor. It's not a hypothetical number. It was the actual number charged and paid by Merrill Lynch, the actual number for the defense of the relevant time period in this case. It's the number, it's the dollars charged, actual number of hours expended. And those come from the time records and the billing records that are attached to the two affidavits. It's an average hourly rate of the attorney time that was actually charged and paid.
But we don't have, there's nothing that sets, I haven't seen it, what those hourly rates are and how that time played out in the work created.
We're trying to establish the value of the work. That's the standard under Section 68. What was the value of the work? And in showing the value of the work, we show that the actual hourly rate, if you do the division of the time and the dollars, comes to an average rate of $648. That was the average rate for the time and the dollars paid. I'm of the opinion that the value of the work that was provided far exceeded this amount of money. Given the nature of this case, it's an esoteric area of business. It requires a lot of experience, not just with respect to the relevant law, but also with respect to the relevant business. In my opinion, the work done during the relevant period of time, the time of recovery here, far exceeded $648 an hour, and certainly is consistent with the rates in the Atlanta metropolitan area for that kind of work.
All right. Thank you.
Thank
Your
you.
Honor,
Unless Mr. Paul has some questions,
oh, sorry.
the witness. Yeah.
I've got 2 or 3 questions, Mr. Laney. Is the statement in place that you just made one that is focused on Rogers and Hardin fees, or are you stating in place something about Merrill Lynch's, not their rates, but Merrill Lynch's division of the money by the hours? I was not clear, because we didn't necessarily object to Rogers and Hardin's records, and we didn't object to the way in which Rogers and Hardin did the analysis. And so it's unclear to me whether you're trying to justify Merrill Lynch or whether you're talking for yourself. Which are you doing?
Well, I'm not doing quite either one. Doing is opining that $648 an hour, which as I understand it is calculated to be the average rate actually charged and paid in this case for all the attorneys providing the defense, is a reasonable rate and consistent with the rate that would be charged in the Atlanta metropolitan area for a case of this complexity.
But you're not saying, are you, that you have gone through and taken on an honest basis every hour that could be spent getting a dismissal order for 5 Utah plaintiffs times 648? You've not done that, have you? You're not doing that. You're not trying to give an opinion on that, are you?
Are you asking me, have I gone through one of the particular motions and multiplied the hours by 648?
I'm asking you, the 648 is nobody's drilling rate. That's a numerical division of money by hours.
It's an average. It's the
that
actual average.
division- Let me finish my question. You're taking that division and saying that's a good rate. But my question is, have you taken what you say is a good rate and actually looked at every inch and ounce of time spent on obtaining dismissal motions against 5 Utah plaintiffs and come out with a number? Have you done that?
I'm sorry, I don't think I understand the question.
I've already said twice. I said
I know.
the 648 is not anybody's hourly rate. That's a division of hours by dollars by hours. All right. So for whatever good it is, that's a division number. Now, I was asking you if you were testifying for your own firm or testifying for O'Melveny. And you sound like you're trying to put it in favor of O'Melveny. And I am asking you, have you taken the hypothetical $648 division number and looked with scrutiny at time actually spent on the 5 plaintiffs and come up with a number? Have you done that?
With respect to the 5 plaintiffs, irrespective
Yes.
of all the other
Yes.
plaintiffs?
Yes.
No.
That's the fees that are being solved. Yes.
No.
All right.
Most of the work is done with respect to virtually all of the plaintiffs, sometimes
No.
all of the plaintiffs.
That's not my question.
Okay.
And so the 648 is just a numerical number based on a universe of fees and a universe of hours, right?
It's based on the actuals, yes.
What?
It's based on the actual hours and the actual money paid
Right.
to both law firms.
But it has nothing to do with anybody looking at the hours spent to get a dismissal order on 5 plaintiffs and seeing what was the cost of that and was it necessary and was it reasonable and what was the value. Nobody's done that, Kevin. Nobody's done that.
No, I don't think I would say that nobody has looked at the.
Well, have you done it?
I've looked at the entries, but I didn't go through every task and say, is this particular task worth 648? But I've gone through the entries on our time records, yes.
I'm not talking about your time records. I'm talking about Merrill Lynch.
Well, and
Melvin.
Ms. Rudson, I think, testified, she's gone through the time records on her, for her firm.
Talking about you.
Okay,
Have
no,
you
I have
gone
not.
through to give an opinion?
I'm not giving an opinion with respect to every specific entry on her time records, but she's done that.
I couldn't, I'm sorry, I couldn't hear you.
Yeah.
So,
I have not gone through to make an opinion with respect to each individual specific entry on her time records, but she has done that.
well, I'm not worried about her. I'm just talking to you.
Well, I've answered that. I have not
You
gone through.
don't have an opinion.
I
You
have
can't say.
not the opinion you just stated. Yeah.
That's right.
All right.
So as Mr. Laney has said, $648 an hour is reasonable in the Atlanta market. And as on a lodestar basis, you can apply that to the over 2,000 hours that were charged in the case. And you'll see that the $1.3 million total is reasonable value for the professional services rendered. It's just a proxy way of looking at it, in the same way that with a contingency fee, you have to look to other indicia of reasonableness. I think we have shown that the 1.3 figure is reasonable. And obviously, for the reasons we've all discussed, there's no way to separate out work done for the Utah plaintiffs from the case as a whole. So the only reasonable way to handle it is to do an allocation. One final thing, Your Honor, and I'll ask you, the Utah plaintiffs have made an accusation against me and Merrill Lynch in both their response and in Mr. Paul's argument that we've apparently done something outrageous or improper in how we've handled the settlement negotiations. They've made false statements of fact about the settlement negotiations here being somehow tied to the Utah case. And so I'm happy to address that, but if Your Honor isn't interested in it, that's fine too. I don't appreciate false accusations being made against me personally and my firm. And so I would like to show the court they're not true, but I defer to you.
Well, I don't understand Mr. Paul to be doing anything more than making an observation about how he felt about how that part of the case was handled. hear a complaint from him or an objection that has anything to do with the pending motion. Am I right about that, Mr. Paul?
Yes. Yes.
Well, then I'd ask Mr. Paul to withdraw his accusation that I did something improper or outrageous.
No. My statement was that at least on 2 occasions in writing, Merrill Lynch insisted that the Utah case be dismissed in order to go forward with a settlement. It could not take place. That's what I said, and that is true. And I've got the writing to show it, so I don't take any of that back. But
Well, so
I passed on Mr. Christian, who would probably have a fit when it's over, because I didn't want to get into that because I was trying to go to the bills and get past that. But it is true why the case didn't settle is because of conditions related to the Utah insistence to be dismissed. So I don't take that back.
So that's where we are, Your Honor. That's not true. Mr. Paul wasn't involved in the settlement discussions. I was, so I can tell you that what he's saying is false, and he's making accusations against me.
Your Honor,
Yes.
may I speak? And I recognize that the court is probably reticent to get into this kind of issue, but I think I can summarize something. There were some papers submitted by the plaintiffs, redacted emails, which as redacted suggest that Merrill included as a condition of settlement dismissal of the Utah claim. When you review the unredacted emails that we submitted last night, you will see that is not accurate. Merrill made an offer. The Utah plaintiffs made a response. They considered how it might be paid, and Merrill offered a path for payment that said installment and letters of credit. That was not acceptable by the others, and it said, alternatively to that payment, we would accept a settlement of this matter with giving you 100% credit for the attorney fees, but in return for a dismissal of the Utah action. Those were alternative positions. It would be inaccurate, in my opinion, to suggest that settlement was unconditionally premised on dismissal of the Utah case. It was an alternative for them. They could have selected it. They could have selected the first option to pay the money that they actually agreed to pay, apparently, initially, but for some reason didn't go forward with it. The emails are there, unredacted, and the conclusion is inescapable that there was no conditioning as it has been described here. Thank you.
Very good. Anything else?
Thank you, Your Honor.
I tried to pass this and I think this is a diversion in terms of what Ms. Rudson put up a case orally, and because she put it up the way she put it, I made a decision not to get into Utah, even though we're prepared to do it. But I don't think getting into Utah has an effect on fees. I think it has an effect on why we are here about fees. And I've got Mr. Christian here, and he may be having a fit to testify, but I passed it because based on what she said, it was unnecessary. And then we're coming back and starting replaying everything that she said the first time. So I'm still going to pass it right now. We got the exhibits. They say what we say they say, and people can furnish whatever other ones. All it is furnish copies of ours unredacted. 408 said we couldn't put in money. We think putting in money is an attempt to prejudice the outcome of the case. We put in the redacted copy as we should have, and they did not. But I think that's an aside, and I will pass on it unless they keep replaying. I don't think it goes anywhere on the issue before the court. It goes to why we're here in the court in the first place.
and that includes, Your Honor, initially, this is Wes Christian, the original idea, which was if we would dismiss our appeal in Utah, there would be no motion for attorney's fees here. So that's how this all started. So I don't want to waste any more time on it because I have a much different version of the facts. No disrespect to opposing counsel, and disagree vehemently as to their characterization. But I agree with Mr. Paul that that's really not relevant to what we're asking you to consider, Your Honor. So.
All right. Okay, then with that, I assume that argument and whatever evidence the parties care to offer is closed, correct?
No, Your Honor, we'll be submitting something after the hearing.
I'm sorry. Yes, yes. And I'll give you, how long would you like?
3 weeks?
Let's see if we can get it done in 1 week.
Okay.
Anything else? All right.
No,
I don't know what she's going to submit, so I don't think anything's signed. I mean, we're done unless she comes up with something that I need to respond to. But,
well, if in fact, when you get her reply next week, if you feel like you want to offer something in response, just let us know and we'll give you some time to do that.
thank you.
Very good.
Thank you, Judge Gogan.
Thank you.
Thank you.
Thank you, Your Honor.
Have a good day.